Um, okay, so our speaker today is Jeff Tenenbaum. Jeff is one of the nation's leading nonprofit attorneys and also an accomplished lecturer, author, commentator, and expert witness on nonprofit legal matters. As managing partner of the nationally recognized Washington, D.C. based Tenenbaum Law Group, a 5-attorney boutique law firm focused exclusively on the legal needs of nonprofits. Jeff counsels his clients on a broad array of legal and sensitive business and governance issues affecting nonprofit organizations. Jeff, would you like to get started?
Thank you very much, Travis. Thanks for the kind introduction. I was just putting a couple of links into the chat with some resources on our firm's website. Well, first off, thanks for having me back. It's good to see you guys again. As you may recall, for those of you who've been on prior ones of these that I've done for you, we have a wealth of resources on our firm's website, even added more since I spoke with you last. Probably about at least 150 different articles and presentations on a whole variety of association and nonprofit legal issues, as well as probably close to 100 now recorded webinars on a variety of different association and nonprofit legal issues. So if you're ever interested in getting more background details on any of the types of things that we're going to talk about here today or other association and nonprofit legal issues, feel free to check there, and the site has a pretty good search feature as well. So as you heard from Travis, I've spent my entire 28-year career serving as legal counsel to associations and nonprofit organizations, all of them in private practice here in DC. Spent the bulk of my career, 20 years, chairing a nonprofit practice at a large law firm called Venable. Started Tenenbaum Law Group almost 4.5 years ago with my law partner, Nisha. We are actually now, well, at least as of yesterday when we had an offer letter signed, we're now a 6-lawyer boutique firm focused exclusively on representing associations and nonprofits. So we represent probably about 750 different nonprofit organizations, primarily national associations and nonprofits, as outside counsel, dealing with the wide array of all of their different legal issues, which is what I've done my whole career. So I have a pretty deep knowledge and expertise and experience with just about every legal issue that your organizations deal with. And hopefully that'll be a good background from which to answer your questions today. So as you know, there's no prepared agenda. There's no PowerPoint presentation. I hate PowerPoints. I literally just did a board training for PBS last week, and the legal staff that was working with me on the PowerPoint said, "Jeff, your PowerPoint is too much text. It's too dense. There's no graphics. It's not good." I said, "I know I am terrible at PowerPoints." They were kind enough to go through and slim it down for me, but thankfully here today, there's no PowerPoint presentations at all. So this is going to be driven by your questions. Make them specific, make them general, whatever you want. If you recall from prior times, I will sometimes take 5 minutes or so before answering your specific question to kind of provide you the necessary background and context in order to be able to help understand the answer to the question. Other times I'll just dive right in. I'll definitely point you to resources like the ones I shared with you, where we have articles or recorded webinars or presentations on our website. And then sometimes if a question is very specific, I might make it a little more general in order to make it widely applicable to everyone. In the rare event that there's a question that falls outside of my wheelhouse and my expertise, I will let you know. We deal with probably 85% of all of the legal issues that our clients bring to us. Our lawyers deal with ourselves, but in certain areas, specialized expertise is required that we just don't have. And if the topics come up in any of those areas, I will let you know. Those are areas where we rely on outsourced legal counsel that we work with to help provide answers to those issues for our clients. So with that, I know we had a couple of questions submitted in advance, but when I just open the floor, you can pose questions. Either it's small groups, or either unmuting yourselves and just asking the question is really the best way to do it, or feel free to post them in the chat as well. Whether it's a specific question or it's a topic you want to learn more about, something you've been dealing with or wondering about recently, the floor is open to your questions.
Okay, well, we had two submitted questions, so I'm going to go ahead and call out those two people and let them ask their question instead of me rereading it. Andrea, would you like to start?
Sure. I don't remember what it was.
Well, I guess
I,
that I can read
I
it for
remember
you.
what it was, 'cause I had,
It was about the 1099s. I was just wondering if you could go over, I saw that there are new rules to determine whether or not your person is a contractor or an employee, and just wanted to see if you could go over the gist of that.
yeah. So first off, few things to point out in this area. This is governed by both employment law, labor and employment law, as well as by tax law. And it's governed both at the federal level and also at the state level, depending on where the employee or contractor is located. So remember, or reminding you that the employment laws, like certain laws, for instance, wherever you're incorporated wherever your nonprofit organization is incorporated, regardless of where you're located, and a lot of like national associations, for instance, are incorporated in one state and located in another. You're always going to be governed by the nonprofit corporation statute of your state of incorporation. But for other laws, including employment laws, employment tax laws, things like that, unemployment insurance, workers' comp, other things like that that go along with being an employee. The state where the employee, or in the case of this question, the contractor is located, is going to be the operative state from a state law perspective. So Andrea, it looks like you're in Colorado. Perhaps all of your employees and contractors are in Colorado, but maybe not. Maybe you're working with someone that helps you with your publications or communications, PR, outsourced HR partner, whatever it might be, who's located in another state. Very common situation. From a state law perspective, that analysis is going to be governed by the state where she or he is located, not where you are based in Colorado. So that's something really important to keep in mind, because this is one area where state laws do vary significantly. Like, for instance, if you have any contractors that you work with in California, it is really difficult right now to be a contractor in California because there's a really strict law that was really written with Uber and Lyft drivers in mind, that makes it's an extremely high bar to be able to classify someone as a contractor as opposed to an employee. So this is so that's one thing I wanted to point out. There's federal law and then there's state law. And they both apply, and they both can give rights to certain individuals. I'm going to call them workers to mean the generic term for whether they're employee or an independent contractor. That's typically what's used. And so you have to be cognizant of both. But for instance, if that worker is located in California and you want to treat them as a contractor, you really have to look hard at the law in California to see if they in fact are eligible. That's one thing I wanted to point out. Second thing is, even if the person is willing to be classified as a contractor, it doesn't mean that you can classify them as a contractor. It's driven by the law, not what the parties choose to do. And sometimes, for instance, even if both parties agree that the person will be a contractor, but later the person gets disgruntled, they get angry at you, or they get, you let them go and they get frustrated or whatnot. Happens all the time. Just got a letter from a lawyer maybe 2 months ago for one of our clients. A person was let go and claimed that they were misclassified as a contractor when they should have been an employee. And this had been going on for years. The supervisor was well aware of all of the issues. And they ended up settling the case for a pretty large sum of money. I think they ended up paying something like close to $100,000 because the person had demanded a lot more, claiming they should have been classified as an employee, not a contractor. Therefore, all of the employer share of payroll taxes should have been paid by the association. All sorts of benefits that they would have been eligible for should have been paid. 401k contributions, health insurance, overtime pay if it's a non-exempt employee. There's a whole host of things that are benefits that are available to employees that are not available to contractors. So there's an obvious incentive, and that's the third thing I want to say. There's an obvious incentive for an employer to treat someone as a contractor rather than an employee, because it's a lot less expensive for the employer, and it's obviously less advantageous for the contractor. But always keep that dynamic in mind. And just because the worker says, I'm fine being classified as a contractor, doesn't mean that they are in fact properly classified as contractors. And there is, I will say, this is one of those areas across the association and nonprofit communities where I think there's rampant noncompliance. Not intentional, not trying to evade the law or just save money, but just rampant noncompliance because people sometimes just don't understand the rules. The two areas we call them classification issues. One is the employee versus independent contractor issue, and the other is exempt versus non-exempt employees. Exempt employees are exempt from the Fair Labor Standards Act, meaning the main benefit is that if someone's exempt, they don't have to be paid overtime for any hours worked over 40 in a week. At least that's a federal law test. Whereas if someone is non-exempt, they do have to be paid time and a half for all hours worked over 40 in a week. And again, you don't just get to decide whether someone's exempt or non-exempt. There's a test, just like there is for employees versus independent contractors. There's a test that is applied to determine which classification the person falls into, exempt or non-exempt employee, or employee versus independent contractor. And as you can imagine, from a financial perspective, there's always more of an incentive to classify someone as an exempt versus non-exempt because you don't have to worry about how many hours they work, track their hours for overtime purposes, pay them time and a half, and things like that. Now, getting into the actual test, I don't know all of the different state law tests, certainly off the top of my head or at all without doing some research. So I can't speak to Colorado, but I can speak to the federal law, which is what you asked about. And this is an area where the federal rule has kind of flip-flopped back and forth between administrations, from the Obama administration to the Trump administration to the Biden administration. Not unusual. A lot of times, a lot of federal rules and regulations, get changed based on the party of who's in the White House. And this is definitely the case here. The Democrat administrations tend to be more employee friendly in their rules, whereas the Republican administrations tend to be more employer friendly. And this is one where under the Trump administration, the Department of Labor had put it, and taken one more step back. I said at the beginning, it's both a labor and employment issue as well as a tax issue. And that is because from a tax perspective, the IRS and state tax authorities care about classification because there's taxes involved. And I'm not just talking about payroll taxes, but other sorts of, well, there are payroll taxes involved, which the IRS enforces, and other taxes as well. And so the IRS has its own tests for employee versus independent contractor, and then the Department of Labor has its own tests. So if it wasn't complicated enough to deal with federal and state law, and sometimes 50 states plus DC, you also have to deal with IRS versus Department of Labor tests. So this is, Andrew, you asked a really complex question, as you can tell. So I'm not going to get into the IRS test.
And I guess the main thing would be, what is the difference? I know that the decision that went into effect a few weeks ago rescinds what we were doing since 2021. So maybe rather, I know it's a complex question, but if you could just highlight what's changed. And I'm not sure, I mean, it may affect, I don't know that it would affect our association, but I was also thinking it from the standpoint of we have so many contractors, as my husband's world. We have so many chiropractors who have 1099 associate docs, and I just started thinking about all the things that it could affect.
Yeah, and people use the word 1099 to refer to contractors because if someone's a contractor, they get an IRS form 1099 at the end of the year, whereas an employee gets an IRS form W-2. But here we're not even talking about the IRS test, but in terms of the Department of Labor. So the new rule took effect, you're right, last month, March 11th. And it returned essentially to the Obama administration test, which is a multi-factor totality of the circumstances and analysis, totality of the circumstances analysis to determine whether someone's classified as an employee or an independent contractor. What that means is you look at all of the different factors. There's multiple factors involved. No one factor is determinative. And you look at these factors to make your determination. And there are 6 factors that the Department of Labor lists, and this is all available on the Department of Labor website. you just do a search for like FLSA, which is the Fair Labor Standards Act. That's where this comes from, and like Google misclassification, you'll come up with it. But the factors are the opportunity for profit or loss depending on managerial skill, the investments by the worker and the potential employer, the degree of permanence of the work relationship, the nature and degree of control, the extent to which the work performed is an integral part of the potential employer's business, and the worker's skill and initiative. Now, you're probably thinking, Jeff, that doesn't really help me much. I don't know what all of that means as applied to your particular workers. And it's a tough one. This is a tough analysis. I will say that one thing that I've always used, it's not any kind of silver bullet determinative test, but to me, it's one factor that kind of stands out above the rest. And that is, does the worker or does the person who's classified as a contractor, and by the way, don't ever say 1099 employee. I hear a lot of people say that. That's like a misnomer. That's combining the two things. There can't be a 1099 employee. They're either an employee or an independent contractor. But if the independent contractor has other clients that they work with besides, say, your association or your chiropractor's office, or your member's chiropractor's office, whatever. If they work for other doctors' offices or other clinics or other hospitals, or I wouldn't be hospitals in your world, but if they have other organizations, companies that they work for, firms besides just that one, that is going to be a very positive fact in terms of treating them as a contractor. I'm not going to say that, because if they did a whole bunch of other things wrong from a classification perspective, they still could possibly be misclassified. But it's going to be, still, you're going to be well on your way to a pretty safe contractor classification if they have other clients. The problem tends to arise the most when the person only works for one employer, for one company, for one firm, and no one else. Whether it's full-time or part-time, doesn't matter, because they're going to be part-time employees. But you're not going to see that factor listed in those 6 factors. But to me, it's a really, really important factor. And if that doctor or whatever or chiropractor only works for one firm and nobody else, that's going to be a big red flag. And you definitely going to want to drill down deeper and probably consult a knowledgeable employment lawyer in your state or the state of wherever the person's working, to kind of help you with the analysis. There are other things, like they say, and this is part of the IRS test as well. And by the way, looking at that same factor, that same issue will help you from an IRS analysis as well. The IRS has this 20-factor test that they use. They say no one factor is determinative. And there are other things which appear in both tests, like the nature and degree of control. So the idea behind a contractor is that you're supposed to be hiring them to perform a task, with deadlines and deliverables and things like that. But the idea is that with a contractor, you're not overseeing them every day. You're not, overseeing their performance and managing them in the way that you would manage an employee. You have a task, you have deliverables, you say, here, go out and do it. And when it's done, you're going to get paid. Now, sometimes there are exceptions to that. Like a contractor could be like, some people hire a law firm, a lawyer with a fixed monthly retainer, right? That's not like paying for deliverables. But the idea is that you're not overseeing that attorney every day to manage them and giving them performance evaluations and other things like that, and controlling the way they do the work. You're kind of just saying, look, this is what we need and want from you. You figure out how to get it to us. So there are other factors like that. There are, some, like the IRS, some of the IRS test factors talk to, like, the contractor shouldn't have an email address from the employer, from the firm, whatever, or the association. But again, sometimes that does happen with contractors because it's, this confidential information being shared, and it's just the easiest way to do that. They say that contractors shouldn't have business cards from, the employers, with the employer's name on it, things like that. That's certainly a good factor. So, long answer to a short question. You opened up a whole series of issues, but it's really important to focus on both the contractor versus employee and the exempt versus non-exempt employee classification issues. And remember, IRS and Department of Labor at the federal level for the contractor issue, and remember state versus federal for both sets of issues. All right, that took way too much time, but you asked the question.
Thank you for that in-depth analysis. Next up, we have Bob from Maine. Would you like to ask your question? You're muted.
Thanks. The question was, if you sign an agreement with a speaker, but then later have to cancel that speaker, what are the obligations? And in this case, I'm going to read a specific contract that was offered to us. It says, if the host cancels the agreement more than 30 days prior to the event, the speaker will retain 50% of the speaker's honorarium that was paid upon signing of the contract. This is a case where we hadn't yet, we've signed a contract, but we haven't made a payment yet.
Okay, first off, are you the host in this situation? You're
Yes.
Yeah. And so first off, I think that you meant to say if the host cancels the agreement less than 30 days.
No, more than 30 days. There's a separate clause for less than 30 days.
Okay. So if it's less than 30 days, does the speaker keep like 75 or 100% of the honorarium?
100%.
Okay, got it. All right, that makes sense.
So the question I have is,
if
we haven't made payment, do we have a contract?
So it sounds, when I read your question in advance, what I think is the case, and it's hard to say without seeing the whole contract, but it sounds like the contract provided this construct, right? That both parties sign the agreement. Once it's signed, you pay essentially a deposit to the speaker, like 50% of the honorarium up front, and then maybe the other 50% gets paid the day of or within 10 days after the event, or however you have it set up. And presuming both parties signed the agreement, you moved ahead, but you just failed to make that 50% payment up front like you were obligated to. It sounds like if I have the facts right, then your association is in breach of the agreement. And just because you didn't follow through and pay like you were supposed to doesn't mean you're not obligated to pay it. Now, that assumes that you had bolded and underlined paid upon signing the contract. So I'm assuming the contract was signed by both parties, but that would be my thought on that.
Okay.
There's always the practical issue of, I don't know, if the speaker, let's say they did some bad stuff, they got, some embarrassing things came out or whatever else, and you just don't want to have them on your program. And I'm not saying this is the case here, but this kind of stuff does come up a lot. If that was the case and you decide, look, we're going to cancel the speaker, even though you might not be able to point to a provision in the contract that allows you to do it, but you kind of should have things in your speaker contracts that allow you to do that. But even if you didn't, you explain to the speaker why you're doing it and that you're not going to be paying them the deposit. The odds are that speaker is not going to come after you. They'd have to sue you to get it back. And so there's the practical issue of, in a situation like that, the practical legal risk to your organization is probably pretty low. At the same time, you don't want to be known as an organization that doesn't fulfill its end of the bargain. And if there's no good reason to not pay, just because it was an oversight, someone forgot to make the 50% deposit when they were supposed to, barring some exceptional circumstances, I'd say you should probably pay it.
Okay, thank you.
Yeah.
Wonderful. Okay. We had some questions submitted beforehand. Now we need some more to fill up this time. Who has questions?
And I'll throw out some topic areas just to get your mind going. We can talk about federal tax exemption issues and unrelated business income tax. We can talk more about contracts. We can talk about meetings and conferences, copyright and trademark issues, other employment issues, executive director and CEO employment contracts. We can talk about legal issues arising from associations' use of AI. We can talk about how to mitigate your legal risk from DEI policies and practices, chapter subsidiaries, affiliate issues, mergers, joint ventures, independent investigations, governmental investigations, anything you want to talk about. Antitrust issues, always a favorite one of mine. So I threw out a few. Let's see what you guys want to hear about.
I would love a brief overview of your thoughts on the AI issues.
Okay. So this is a very hot topic, as you might imagine. It's a hot topic in our country generally, and it's a hot topic for associations and nonprofits. In fact, I just printed out this article that was in ASAE's daily newsletter today called "What Meeting Pros Need to Know About Generative AI." I'm always trying to kind of understand how associations and nonprofits are using AI, because that really helps to inform, what are the practical legal risks and how can you mitigate them? And the ways that associations are using AI is evolving rapidly, are evolving rapidly. There's no question about it. So let me try to make this as brief as possible. I've given entire webinars on this topic. There are some on our website, the recordings that I sent you the link to, if you want to hear more about this. And there's also an article that I wrote on the topic, fairly high level, but still should be helpful to you. That's under the publications part of our website. So first thing I want to stress is that some, not all, but some of the legal risks from AI, and we're generally talking about generative AI, like ChatGPT, and also Bard and Claude. These are some of the other leading platforms that a lot of associations are using. Some of the legal risks from using generative AI can be mitigated by the type of platform that you're using and what options you select in that platform. And those options are generally, like for ChatGPT, it has to be a certain level, like a paid subscription that you get, not the free version. But if you get those versions, or if you're large enough to pay for like an enterprise version, like for all of your staff to use, that you put out, you install in your own system, or get access to on your own system. In any of those situations, you can essentially turn off the ability of the platform to utilize your inputs. Inputs meaning the things that you are putting into the platform: data, questions, information, articles that you want the platform to compile or analyze or sort through, or the same with data or other things like that. These are all the inputs, the things that you are putting into it. And the way the default rule for most of the platforms, Claude being an exception to this, is that the platforms take everything that's put in there and it gets added in with everything else that the platform uses to learn and to grow and to answer other people's inputs and questions and things like that. To train its algorithms and to improve its business. These are things that the platforms utilize your inputs for. But you have the ability under some of these platforms and some of these versions to turn off the ability of the platform to use your inputs. Because some of the risk, whether it's confidential proprietary information, personal health information, personal financial information, privileged information, copyright protected information, a lot of things you don't want to get out there. Things that could give rise to all sorts of liabilities: employment liability, violation of privacy, copyright infringement, other things like that. And so if the inputs don't go anywhere and they're not utilized by the platform, that's going to take away some of those legal risks. So that's one thing I strongly encourage you to do. And of course, that also means for your employees that you have to make sure that your employees are instructed. You want to have some sort of an AI usage policy for your staff that requires them to only utilize, the platform or platforms that you are directing them to use using those kind of features. That's really important, because none of this does any good if your employees are just going on to their own search engine, pulling up their own version of ChatGPT that they use for their own personal lives and start using it to do work for the association. That's not going to do you any good. You need to direct them and instruct them to only use it in the way that you direct them to. So that's one thing that you can do to help mitigate risks. Another thing is that it really comes from the outputs. So for instance, if you are utilizing ChatGPT or whatever to help create a first draft of an article or a speech or something like that, that you're going to deliver, and you just ask some questions, you put in some information, you get something spit out, and then you want to take that article and you want to register it with the Copyright Office to help maximize your protection of it. Copyright registration is only available if it has to meet certain other requirements. In addition, it has to be a product of human creation. So something that just comes from an AI platform is not going to be the subject of human creation. You're going to have to put enough human element into it work into it to make it a product of human creation. And then, of course, it has to be an original expression of ideas, and it can't be infringing others' copyrights and all the things that have existed well before AI. That's one issue. Another issue is employment discrimination. So a lot of associations, well, some associations, particularly larger ones, are utilizing AI to help them screen resumes for job applications, as well as because like we just hired a new attorney, but we also were about to hire a new administrative assistant. Just from my posting on LinkedIn a few weeks ago, we got over 1,500 applications for administrative assistant from all across the country. That's a lot to process. And so if you can utilize AI to help sort through those applications and help wean them down to ones that are the most qualified, right, that's pretty attractive for you to do. But the problem is that these platforms have built-in biases because they use information that's out there on the web and elsewhere that, as we all know, has built-in biases. There's evidence of that all of the time. And those built-in biases, if not properly, if there isn't enough human intervention to vet those and kind of engage in sufficient human due diligence, those built-in biases can end up screening out resumes, for instance, in a discriminatory manner that can give rise to potential employment discrimination for your association. So that's another important issue to keep in mind. Also, something called tort liability. This is kind of liability for injuries, usually on the basis of negligence. All sorts of associations, including those in kind of the medical and kind of quasi-medical spaces, are, for years have put out standards, clinical practice guidelines, patient guidelines, other things like that. Really important, valuable function that associations carry out. But this has always been the case. I wrote an article about this 20 years ago, how associations are potentially liable for those things if those standards, if those the guidelines are negligent in the advice that they're giving, and that negligence causes injury or harm to someone, you can potentially be liable as an association for that harm. So this is something that's not new at all, but what is new is that some associations are utilizing AI to help generate those guidelines, standards, or to come up with new versions of them and things like that. And if you're going to be relying on AI for help in doing that, again, you have to make sure there's proper kind of human accountability for every AI action, determination, suggestion, things like that. Another issue that I get asked about a lot is, again, this is nothing new from a liability perspective, but it's new from a technological perspective. And that is that whether it's a recording, like we're seeing here, right, a recording of this webinar, or these AI bots that are note takers, we're increasingly seeing associations utilize either recordings or AI note takers to essentially create a recording or a transcription of meetings, board meetings, committee meetings, things like that. And some of these are actually pretty good, not just of creating a transcript of he said, she said, but actually organizing and sorting this stuff. The problem or the risk is that when you have this kind of unvetted, kind of word for word, essentially transcription of everything that was said, whether it's, the tort liability suit that I talked about, or the employment discrimination suit that I talked about, or an antitrust lawsuit, which I'm going to talk about in a second, all of those things, the plaintiff's lawyer or the regulator that brings the case would love to get access to that through the discovery process, because a lot of times that can be just a treasure trove for a plaintiff's lawyer or a regulator. And that's extremely dangerous. Unless it's subject to the attorney-client privilege, all that's going to be discoverable. And so what I've been telling clients is, look, if you feel you need to do that solely for the purpose of creating minutes, meeting minutes, and then you're going to be sure that those things get destroyed immediately after the minutes are approved, I can live with that. But otherwise, you really don't want to have that living out there. And actually, the CEO of a client just asked me a couple of days ago, he said, okay, I get that. I gave him that advice. That makes sense. But he said, what about like a staff person who just takes notes of a meeting, and that person essentially takes almost a transcript of everything that was said? I said the same basic guidance and rules is going to apply there as well. You just don't want to have that kind of a paper trail. That's why associations adopt record retention and disruption policies, things like that, to make sure that things get regularly destroyed so we don't have that paper trail for the litigators and the regulators. And then finally, you want to make sure that you have appropriate policies for staff, like I talked about, AI usage policies, for contractors, for vendors, for speakers, for authors, consultants, perhaps even for board members or committee members, and make sure that you educate them about those either whether it's provisions in a contract or separate policies, educate them and enforce them. It's really, really important. So that's a high level nutshell, Travis, of kind of some of the liability risks in connection with AI usage, but this will continue to evolve. I see that Rachel's asking about kind of any updates regarding antitrust laws. So not really anything new. One relatively new thing that happened about, I don't know, a year and a half ago is that the Department of Justice and the Federal Trade Commission essentially took away or deactivated the safe harbor that had existed for over almost 25 years for associations and others that do information gathering, benchmarking surveys, things like that, gathering like competitively sensitive information, salary surveys, price surveys, fee surveys, things like that. And, that safe harbor basically said, if you have a group of competitors, like a group of chiropractors, or part of an association or whatnot, and they want to gather competitively sensitive information from the members, for instance, if you follow these 5 steps, it's going to be a safe harbor to protect you from antitrust liability, primarily for price fixing. And they are things like, you want the information gathered either by the association staff or, outside consulting firms, not by the members themselves. You want to be sure that members never have access to the raw data, that there's at least that all data is going to be aggregated in any published surveys or studies, that there's going to be at least 5 participants in each data category, and no one participant's data can constitute more than 25% of the total. And if you follow those steps, they said that's going to be a safe harbor from antitrust liability. They took that down, but I will say, so that's new, but I'm still giving the same advice to clients as are other attorneys that advise on association antitrust issues, because it's still a good practice. It's not the technical safe harbor that it was before, but if you're going to do it, it seems to me it's still and one other really important factor I forgot, that the data collected at the time of collection has to be at least 3 months old. This is arguably the most important point. So you can't be asking about current data, like what kind of fees are you charging to patients, or what sort of compensation increases you're going to be giving your staff next year. No current information, no forward-looking information, but it has to be at least 3 months old at the time of collection. And I still think it's really solid advice. The rest, all of it, and there's some good resources on our website about association antitrust issues. I do a lot of trainings on this stuff for boards and for staff. Nothing new, but just as important, even though things haven't changed much. I mean, the antitrust laws have been around for over 100 years. The main antitrust laws at the federal level are the Sherman Act, the Clayton Act, and the Federal Trade Commission Act. Some of the most notable areas of liability risk for associations, which are groups of competitors, and the antitrust, some of the antitrust laws are what we call vertical laws, like the recent case that the Department of Justice brought against Apple. Those have to do with monopolies and abuses of monopolies and whatnot, and mergers, like the merger between maybe JetBlue and Spirit or something that was forcibly denied by the Justice Department. Those are the vertical antitrust laws. What I'm talking about for associations are the horizontal ones, the ones that apply to actions between and among competitors. Because associations are, by definition, combinations of competitors, you already meet one of the requirements of some of these antitrust violations. The ones that we deal with the most and we try to mitigate the risk of the most in the association world are price fixing, which is 2 or more competitors, like an association, agreeing on prices or fees to be charged, as well as factors that go into price, like salaries and compensation. Group boycotts, where a group of competitors agree to not do business with a particular company or individual, or not let them into your association, or not let them exhibit at your trade show, or other things like that, or kicking them out of membership. A market allocation, where competitors agree to divide up the market amongst themselves and not compete with each other in certain segments of the market, whether it's geographical or by type of service or otherwise. Output restrictions where competitors like members agree to, say, open, open fewer hours for your, services, or open fewer new, brick and mortar, places of operation, or other things like that. Any sort of agreement to reduce output is a serious antitrust violation. Bid rigging is another. And so these are the types of things that associations really want to work hard to mitigate the risk of. And one final thing I'll say is that to the extent that you engage in lobbying, like a lot of associations, including in the medical and quasi-medical spaces, will regularly be lobbying like state legislatures and state regulatory bodies and federal Congress and federal regulatory bodies, to, for instance, try to keep other professions from getting into your world. Trying to preserve some sort of more favorable licensing construct for chiropractors that might be anti-competitive, but the U.S. Supreme Court, which has interpreted these laws over the last 100+ years, has said that if it's bona fide lobbying, even lobbying for an anti-competitive outcome, that's protected by the First Amendment, and that it does not constitute an antitrust violation. So to the extent you do engage in that sort of lobbying, as long as it's bona fide lobbying, it's not some sham, that's going to be protected and exempt from any antitrust liability. Again, that's another high-level overview of topics that I typically spend at least an hour talking about, but hopefully that helps you. Brandy says she has a question.
Yeah, thank you. My question, can you comment on the beneficial ownership information reporting requirements, specifically who's required to report, and do the exemptions impact our healthcare offices?
I think I know what you're talking about. It goes, what is it? CTA? I can't remember the acronym for the law. And we just looked at this last week for a client. I think that's the one you're talking about. Basically, there is an exception for tax-exempt nonprofit organizations. And so associations are not going to be covered by this. Yeah, I believe it's through FinCEN. And if that's the one we're talking about, associations are going to be exempt from that. As to your members, that's outside of my wheelhouse. I could not comment on that, but I believe I remember looking at the general exemptions, and there's, to my recollection, there's no broad category of exemption that would apply to healthcare providers or something like that. But I really can't speak to that, unfortunately. Yeah, I would talk to a healthcare regulatory lawyer. All right, other questions on these topics we talked about, or anything else?
Can I ask a follow-up to the AI question? You broke up a little bit when you were talking specifically about the kind of the record keeping along the lines of minutes and stuff like that, and having that available. Were you talking about if you input that information, it's viewable, findable, if somebody goes digging for it, or were you just talking about records that associations keep?
No, I wasn't talking about that. Well, certainly, again, if you have that ability of the platform to utilize your inputs, if you have that turned off, then that's obviously less of an issue. I still think you want to take a belt and suspenders approach and never put into the platform anything that's super confidential or sensitive that you wouldn't want shared. But sometimes you really want to have the platform analyze some really sensitive data, and because AI platforms can do things that humans cannot, and it can be really valuable. But as long as you have that sharing feature turned off, or Claude is a platform that by default it doesn't have a sharing allowed with a few minor exceptions, then you should be okay on that front. But no, I was talking about something completely different. I'm talking about, particularly from the AI component, it's those note-taking features. And you've probably all been on calls where you see, oh, there's another box on the Zoom platform. It's, the AI bot who's taking notes of this thing. And it certainly can be very convenient. And I've not used one of these myself, but I've heard that they can be very helpful in sorting and analyzing the information and whatnot. And I'm not, like I said, I'm not necessarily opposed to it if it, avoids the need for, say, a staff person to take vociferous notes during the call and can enable them to more focus on the content and the substance. But, if it's going to be utilized to create meeting minutes. Meeting minutes should never be, he said, Jane said this and John said this and this person countered it. They should never reflect that. There's just too much risk of that being kind of a treasure trove for lawyers in a lawsuit or regulators doing an investigation or bringing in enforcement action. They should just be a summary of, the board discussed, the board discussed new candidates for the board of directors, and then the board voted to approve the slate and send it to the members for a vote. And here's the slate. Or, the board considered a proposal from XYZ firm to conduct this big study. The board determined that appropriate due diligence was done and it was competitively bid, and the board voted to hire this firm to conduct this study. It should be just summary fashion like that. They should never be too long or detailed for all the reasons I just described. And all I'm saying is that if you're going to use whether a video recording or an audio recording or an AI note taker to provide you with some broader raw material to be able to rely on in creating those minutes, that's fine, as long as you have a policy and a practice of making sure that stuff is destroyed after. And obviously not everything's equal. Some things might have less of a liability risk, but generally speaking, lawyers do not like to see those transcripts laying around. I get involved in way too many lawsuits, for our clients, lawsuits, investigations, enforcement actions, and even what are called third-party subpoenas. I don't know if your organizations have ever received them, but it's very common for associations. We probably get one from our clients to look at every other week. And these are where the association is not a party to the lawsuit. Let's say it's a personal injury suit or a malpractice suit or something like that. And we had one recently. It's an association, a National Association of Nurses that we represent. And there's an allegation that the nurse at some hospital, I forget where, was negligent and didn't properly monitor the patient, and I think the patient died. And the plaintiff's lawyer is trying to show that the nurse did not live up to the professional standards and guidance that were put out by my client, the association. And so they're asking for a whole bunch of information and documentation regarding those standards and whatnot, and also whether this particular individual had taken certain courses and was certified and things like that. This is very common. You generally have an obligation to comply with those third-party subpoenas unless it's completely irrelevant or it's subject to the attorney-client privilege. You have an obligation to disclose that. But if you don't have it, you don't have to disclose it. And that's why I'm saying it can make your lives a lot easier if you don't have transcripts laying around of all sorts of things that could be very interesting to a plaintiff's lawyer.
Okay. Thank you, Jeff. Any other questions? Got a couple minutes left. Wonderful. Oh, Mark.
Sure, Jeff, can we just back up a smidgen on the FinCEN beneficial ownership stuff? You indicated associations are exempt from that. What about wholly owned subsidiaries? Have you been able to dig into that at all?
Again, this is not an issue that we've dug into much at all, but we have gotten a couple. It's the Corporate Transparency Act. That's what we're talking about here. Right. And that's what requires these beneficial ownership reports. Yeah, I'm just pulling this up from an email that I sent to a client. There is an exempt, so there's like 25 plus different exemptions. And of course, as I told you, there's an exemption for tax exempt organizations. And that, by the way, that's not, there's a creature called a taxable nonprofit. That's like a nonprofit corporation. That's a nonprofit for state law purposes, but usually for disclosure reasons or compliance reasons, chooses not to be tax exempt. Those nonprofits would not be exempt, but a tax exempt entity is one of the exemptions. And then there's another one for an entity assisting a tax exempt organization if the entity satisfies 4 different requirements. One is operates exclusively to provide financial assistance or hold governance rights over any of the tax-exempt entities that are excluded entities, is a U.S. person or company, is beneficially owned or controlled by one or more persons that are U.S. citizens or lawfully admitted to the U.S. and derives at least a majority of the funding or revenue from one or more U.S. persons or citizens that are lawfully admitted for permanent residence. And so the question from our client was, they have a what's called a single member LLC, limited liability company. We utilize these a lot. We actually set it up for them. And that LLC conducts standard setting. And because standard setting, for reasons that I described earlier when I was talking about tort liability risk, and I gave some examples, because standard setting can be a particularly risky activity from a liability perspective. We put that standard setting operation into a single member LLC. The advantage of a single member LLC is that it's a separate company, so it creates a liability shield like any new company does. The corporate veil, they call it, the corporate status itself. Essentially, if you do it right and you follow the appropriate corporate formalities, can help to isolate those liabilities within that LLC and protect, say, the parent entity that's the sole member, the sole owner of the LLC, from liability. But for federal tax exemption purposes, it's what's called a disregarded entity. So it shares the tax exempt status of the parent organization, which is really a nice construct, and we use it all the time. And so what we told our client is that for their disregarded LLC, it would seem to fit squarely within another exemption, which is a subsidiary of certain tax exempt organizations whose ownership interests are controlled or wholly owned by a 501c tax exempt organization. So it's exemption 22, and that is the one you're going to want to look at in trying to determine whether any subsidiaries of your tax exempt association are going to be covered by that exemption. Yeah, Rachel, you had a question. I don't know if it's on this or something else.
No, something completely different. So I hope that answered Mark's question. Just laughing at him. I know we're at the top of the hour, but I just had wanted to ask a general question just to see if you've seen any new trends specifically with executive director employment contracts. I don't know, maybe they're looking at changing something specifically in there, or just some sort of trend maybe. And again, this is for maybe smaller associations, not necessarily the ASAEs of the world, but most of us chiropractors, covered associations are a little bit smaller budgets than them, but just curious.
Yeah, it's a great question. And we work on more association and nonprofit CEO employment contracts than I've ever worked on my whole career. We're probably working on 5 a week, seems like, at any one time. I was just at a client board meeting. It's a state association, but a pretty good sized one. I was at a board meeting yesterday where they were approving kind of the terms of a new contract for their executive director. And I will say, one of the things that came up there, and I was also sitting next to a compensation consultant who did the compensation study for them, and she noted this as well. One trend, I wouldn't say it's a trend yet, but I'm seeing it a little more, is to get rid of the annual performance bonus and just build it into the salary, kind of rolling it all into one. Historically, with association CEO contracts, you got your base salary and whether that increases year to year, and then you have your annual bonus, which is usually capped at anywhere from 10 to maybe 30% of the base salary, completely performance-based, discretionary on the part of the board or the executive committee or the compensation committee. And I'm not arguing for this or saying it's good or bad or right or wrong, but we are starting to see a little more getting rid of the bonus and just rolling it all into base salary. And from a compensation, like a comparability data and fair market value perspective, what matters is total compensation. Total compensation has to be reasonable and not above fair market value. That's why you should be at least using compensation studies or published compensation data if you don't have the ability to hire a compensation consultant to do an actual specific study for you, say every 3 years. But in the end, kind of doesn't matter. What matters is that the total compensation has to be reasonable. So if you're comparing your comp to others in similarly sized, similarly situated organizations, you really want to be looking at total cash compensation, along with other non-cash compensation as well. Other trends that we've kind of seen in recent years is much back in, I've been doing this for 28 years. In the beginning of my practice, there were a lot more perks and benefits available to executives from associations, you know, whether it's a car or a car allowance or, you know, country club or downtown luncheon club dues or spouse travel or other things like that, first class travel, that definitely still exists in some CEO contracts, at least for longer travel, like international travel and things like that. But in part for whatever reasons, and in part because since 2008, the IRS requires disclosure of some of those perks on the Form 990. And so a lot of associations didn't want to have to disclose that stuff, gotten away from more of those perks and just kind of rolled it all into compensation. Deferred compensation for larger organizations is still something we see a lot, both 457B plans and 457F plans. You know, in terms of, these aren't really new changes or different things, but to me, some of the most important elements in a CEO employment contract are the term, how long it is, how it can be terminated before the end of the term, whether it automatically rolls over into like additional one-year terms, and how that process can be stopped. Severance pay, very important for the executive, that if the agreement gets terminated without cause during the term of the contract, that the executive is going to get severance pay, and not just pay, but a lot of times covering the COBRA premiums as well for health insurance. The definition of cause, therefore, is really important, because if someone gets terminated for cause, you're not going to get severance pay. So when we represent the executives, which we do a lot, you know, we represent both, not at the same time, but when we represent the executives, it's really important to us to make sure that the definition of cause is not too broad, that it's properly narrowed. And we have come up with some really good language, different iterations of it, that I think are really fair and balanced for both the employer and the employee. You know, so you just, like, poor performance or, you know, not being responsive to the board or things like that, you can drive a truck through those cause definitions. You don't want that as an exec. You want to have it be very narrow for essentially the really bad stuff. And so that otherwise, if you get terminated during the term of the agreement, that it's termination, that you get severance pay. Another thing that we push for when we represent the exec is that if the agreement does not get renewed, that you get severance pay. Usually, we end up settling on half of the normal severance amount for a midterm termination. Take 50% of that, and that's what the exec gets in the event of non-renewal of the contract. And then something not to be overlooked, we always ask when we're representing the exec for reimbursement of legal fees, usually up to a cap of, say, like $2,500. But it's no harm in asking. I'd say we get it probably 50% of the time. But certainly if you can get your employer to pay for your legal fees, which, you know, is really, really important. I also deal with a lot of CEOs that come to me when they're going to be terminated. You know, they've got notice of termination, and then we negotiate for the, you know, what the employee is going to get, what the CEO is going to get. How that contract was written in the first place has a huge impact on how much bargaining power we have in that severance negotiation for the severance agreement. And you cannot underestimate how important those contracts are. So we're over time by a few minutes, but hopefully that gives you a little bit of a high level overview of some of these issues. But if you ever have any questions on that, let me know. We do extensive work in this area, and I also do a lot of speaking on the topic as well.
Okay, thank you, Jeff. Thank you, everyone, for being here. Our next Lunch and Learn is May 1st. Again, ICD 11 implementation, or preparation for ICD 11 implementation. I thank you all for being here, and have a